All right, we are live now, and just let me put a couple of things on here. Okay, I think we have everything running now. So this is the 187th District Court. Today is Friday. Let's keep it as a Friday. Let's not try to turn it into a Monday. These are the rules. You are in a courtroom. You may be at your home, you may be in your car, but you're in a courtroom and you need to behave as though you are in a courtroom. To all of the inmates, you're not allowed to use the chat box. If you use the chat box, you will be sent back. To all of the inmates and everyone else on this screen, this is not a chance for you to pick up dates. Do not use your chat box because you see someone that you want to date. I know you're probably saying, why is she telling us this? Because it has happened before. If you are not at your home, or even if you are at your home, wherever you may be, you need to make sure that you find a stationary place. There's to be no laying in bed. Anything that you could not do if you were physically in the courtroom, you cannot do on this Zoom screen. To all the attorneys, if you have a plea bargain agreement, put it in the chat box, no matter how small you think it is. You need to put it in the chat box to Norma Ferguson. She's listed as Ferguson coordinator so that she can get the paperwork she needs to get to you. To all the attorneys, if you're looking for a reset, please do not text, chat, or email Ms. Ferguson or call her. I'm the only one who can give you a reset and excuse you. I'm going to open up breakout rooms. When I open up the breakout rooms, it's going to invite everyone to go to a breakout room. Do not go to a breakout room unless I specifically call your name and invite you to a breakout room. To all the persons on this screen who are defendants and accused, your name will not be called. Your attorney's name will be called. If you do not hear your attorney's name, it's because they are Zooming in another courtroom. Trust me, you will get a chance to see your attorney. So please do not raise your hand and say, I didn't hear my attorney's name call, because my answer to you is going to be, they're Zooming in another courtroom. They will be here as soon as they can be. And also, I'm going to be sending attorneys to breakout rooms. When your attorney goes to a breakout room, if they want you to go to that breakout room, they will request that you go to that breakout room. Usually what ends up happening is an attorney will want to speak to someone from the state first. After they speak with the state, then they will request you to be in a breakout room. I'm going to call the names of the attorneys. Attorneys, this is the order in which you'll appear. If you need to go to another courtroom because you see you're low on the list, you're more than welcome to do that. However, if you go to another courtroom and your name is called, you will be skipped over. This is the order of attorneys. Arnulfo Ortiz, John Fox, Daniel Velo, Tart McCrae, Ling Han, Joseph Acevedo, and Jorge Aristotelides. Sorry, is there anyone whose name I missed? All right, to attorneys. When I call your name, I'm going to need to know the name of your client, and I need to know whether it's family violence or criminal trial division. When you go to a breakout room, please be patient. I always tell people to put some patience in your pocket, pull it out whenever you need it. Think of these breakout rooms as a doctor's office. When you call back to go to the doctor, you really don't get a chance to see the doctor yet. They put you in a small room to check your weight and your blood pressure. So please be patient. Arnulfo Ortiz.
Good morning, Your Honor. Present.
Who do you have?
I have Sonia Sotelo, 2020, 1300.
Is it Family Violence or Criminal Trial Division?
Criminal Trial Division, Your Honor.
All right, I'm going to send you to breakout room number 2. A prosecutor will meet you there.
It was a motion to early terminate, but I'll go wherever you tell me to.
Number 2, and see if you can confer with the state, see if they have any objections to it.
Thank you, Your Honor.
You're welcome. John Fox?
Morning, Your Honor. I have Anthony Asmus, and it's Criminal Trial Division, and I've been conferring with Tom. I think I need to follow up with him.
All right, I'll send you to breakout room number 3.
Thank you, Judge.
You're welcome. Dan Vela, I know what you're here for. Just give me one moment.
Okay, thank you, Your Honor. Good morning.
Judge, I send you a chat.
All right. Could the prosecutor go to breakout room number 2, please, and let Mr. Arnulfo Ortiz that his probation case has already been heard and that early termination was granted. All right, Todd McRae.
Good morning, Judge.
morning.
This is Victor Pazana. It's a CTD case. I need to speak to Tom Nisbet, please.
Can you spell the last name for me, please?
Pizana. The bond condition modification.
All right, I'm going to send you to breakout room number 4.
Thank you.
You're welcome. Ling Hong.
Good morning, Judge. Sorry, I was trying to change my screen name, but I was not able to.
No problem.
I'm here for John Bueno.
And is it criminal trial division or family violence?
And I'm not sure. I know that I've been speaking with Jordan Brown with the Conviction Integrity Unit.
Could a prosecutor see if they can get integrity unit here, please? We're gonna see if we can get them here. Just a moment.
Thank you, Judge.
You're welcome. Joseph Acevedo.
Yes, Your Honor.
Yes, who do you have?
William Norton, Criminal Division.
You say Barton?
William Norton,
Norton, okay.
Criminal Division.
All right, I'm gonna send you to breakout room. Let me see what's on. Number 5.
Thank you.
You're welcome. Jorge Aristotelidis.
Good morning, Judge.
Good morning.
We're here in the recurring issue of my client's condition while on deferred adjudication. I have, the last time that we appeared, I mentioned to, I believe it was visiting Judge Her, that I would be working on a motion to modify this condition. I have already prepared the draft, but I'm waiting for information from my client's therapist. There's a social anxiety disorder issue that I would like to raise with the court to present mitigating information that would help the court determine whether and to what degree to modify the requirement that my client move completely out of his house and by himself in an apartment, or other conditions.
Okay.
So I'm asking for more time, Judge. A lot of stuff has been falling on me right now. I have several settings, several good number of motions in federal court. It's taking a lot of time, Judge. It's
Okay,
just,
how much time are you requesting?
would you allow me 30 days, Your Honor?
Okay, just one moment. Give me one moment. Let me go through the list and I'll come right back to you.
Yes, Your Honor.
Thank you. Nathaniel Navy.
Good morning, Judge. I'm here on sentencing for Kirk Kinnear, K-N-E-H-R. I've looked through my emails and I don't think I've received a PSI. So if probation has one, if they could send me a copy.
Okay, thank you. All right, probation, if you could forward that, please. All right, Anthony Cantrell.
Good morning, Judge. I'm here on Mr. Hawkins,
What's the full name, please?
Robert Hawkins. Reuben Hawkins, I'm sorry, Reuben.
Is it Criminal Trial Division or Family Violence?
It is Criminal Trial Division, and I've been speaking to Tom Nisbet.
Okay. I'm going to send you to breakout room number 6.
Thank you very much.
You're welcome. All right, so Dan Vela.
Yes, Your Honor.
All right, on your client, the court received an email from probation.
One moment, Your Honor. He's here. I just have him sitting over here.
Okay, what is your client's name?
Mr. Romo, Gerardo Romo.
All right. So the court received an email from probation regarding CPS case. And I know you were saying that it was not within the court's, well, not within the court's purview, that it really should be handled by CPS court or by a civil judge about his conditions of visitation. So the email I received from CPS court through probation is that I've given him more than what they would give him. So the court coordinator, the court reporter is not on now. She's running late, but I'm going to change my order because according to the CPS order, your client is only allowed to have supervised telephone contact, not supervised visitation. And I know we were here because you wanted the court's order of supervised visitation to be lifted by the court. But my understanding is CPS is only allowing supervised phone conversation. So is that correct or no?
Your Honor, may I address the court regarding that?
Yes.
That was the order at the time of the CPS hearing before Judge Canales then. However, and if the probation officer is going to provide you emails, I can also provide you emails.
Yes, please provide. Here's the thing. I want somebody to provide me the order because I don't want to give him more than what they've given him. I'm still at the point of supervised contact.
Your Honor, may I address that? That's correct.
Yes.
We want to comply with your order. There's that first and foremost.
No. I understand that, but I want to know what is the civil court asking for?
Here's what happened. We did have a hearing, a 262 hearing before Judge Canales. Unrelated to this matter, right? Obviously that had happened over there. The order at that time was that he be provided telephonic visits. However, after that hearing, and I can provide proof of this, there is a CPS caseworker that interviewed the child. Obviously they interview the child and they do all that. They do more involvement with the child on that end than we do on this end on the criminal side. And they have interviewed the child. They have talked to the child. And there is a CPS caseworker who works for the state who is willing to supervise contact between Mr. Romo and the child. And I have emails to that effect. Now, I will show that to the court. I have shown that to Ms. Bridget Clay over on the CPS side. She's been emailed repeatedly throughout this whole time. There's threads and threads of emails regarding that. I believe that very shortly that order will be changed. So here we're going to come back again if that order is changed because
no. This is what I want. Somebody show me the CPS. The civil order from Judge Canales saying that he's allowed to have more than supervised telephone contact.
I will show.
Here's the thing. I'm not taking anything as true. That's why everybody is here. So I want to see.
They need to see him.
So I want to see.
I want him.
No. So I want the civil order that says that he is receiving more than supervised telephone contact.
I will.
I mean, there should be a court order that says he's allowed to have supervised visitation. But what I'm telling defense counsel is what the email the court has received. And I want everyone to know the email I received from probation was they wanted clarification of the court's order because they didn't know what to do, because the civil order, what they told me, said that he was only supposed to have supervised telephone contact, no supervised in-person contact, only telephone contact. So someone showed me an order where it's saying that he's allowed to have more than supervised telephone contact. That's all I'm asking for.
I'll get you a copy of that order. May I interject one other thing, Your Honor?
Sure.
I was there at that hearing, and I'm not, as an officer of the court, I'm going to tell you what that order was. And I will show you that in writing also. But you're right, it was a telephonic supervised contact at this time. I'm expecting that to be amended very, very shortly. And then here we're going to come again, right? Because then that's going to conflict with your order again. So here we're going to be constantly ping-ponging back and forth between the criminal.
No,
court.
it doesn't. No, it doesn't. Here's the thing. It doesn't conflict. For example, I'm still at, yes, supervised contact. However, if the civil side is saying he can only have supervised telephonic contact, I'm not, as a criminal court, I'm not going to give him more contact than what the civil side is asking for. That's what I'm saying. So obviously, if they're only giving him supervised telephone contact, they have seen something that this court has not seen. That's what I'm saying.
Here's what thing, Your Honor. When that order, first of all, I'll get a copy of that order to the court. I will also show the thread of emails that show that there is a caseworker willing to supervise visits with him in person. I'll do both those things. But third, that order, I expect it to be what the court says, which is only telephonic at this point. When that order gets amended, where I expect it to do, we're going to be in the same situation, because you're going to have one that says supervised telephonic, then they're going to have one that says supervised visits. So then we're going to come back again.
No, then people will need to come back. So what the court is going to do, my order, I'm not giving him more than what CPS is giving him. If CPS is saying he can only have supervised telephone contact, then he's only getting supervised telephone contact from this court. And if something changes on the CPS side and people want to have a hearing, I'm here from 9 to 5. I'm willing to listen to it. But for now, this court is rescinding its order, and he can only have supervised telephone contact. I am not going to give him more than what the civil judge is giving him. If the civil judge decides to change it and says that he can have supervised contact, then I will do supervised contact, but I'm not going to give him more than what the civil court is giving him.
We're not going to be in whatever the court wants to do. We weren't going to violate, obviously, the terms of this court. If the court says, my plan was, just so the court's aware, on that end, there was a supervised, what the court says is what the court's ruling was as to the CPS, which is telephonic contact at this point. However, I understand this criminal court's ruling as it stood prior to today. So when that court over there was willing to do CPS supervised visits, I thought, okay, well then now we're in compliance with both courts, right? We're in compliance with their order and we're in compliance with their order at that point. Now, with the court's order today, now it's gonna be a ping pong situation, Your Honor, but if that's what the court wants to rule, that's what the court wants to rule.
Well, no, I don't think it'll be a ping pong situation, because my understanding, and if I'm wrong, let me know. Everyone, if I'm wrong on something, let me know. I want to make sure that I'm understanding correctly. So first question, is CPS court only allowing supervised telephone contact?
From my understanding of the order that on the 262 at this moment, yes.
All right, so then this court is only going to allow supervised telephone contact. And Mr. Vela, if at some point in time, CPS court issues an order and says that he can have supervised visitation, then bring it to me. I will consider it. But my thing is, I've read your order for the order that you filed asking that he be allowed to have contact. You were saying it was interfering with his ability to be a parent, but I am mirroring for now, I'm mirroring what the CPS court is doing. And so they're saying supervised telephone contact with minors. So I will say supervised telephone contact with his minor child. And this is his child, correct?
This is his child, yes.
And outside of the supervised contact, telephone contact with his minor child, he's not to have any other unsupervised contact with any other minors. So he's allowed to have supervised contact with his minor child, but he's not allowed to have any unsupervised contact with any other children.
Understood. Your Honor, two other things. I'm going to get you a copy of that order. I'm going to show
Thank
you
you.
the thread of emails. Where do I send them to? Do I send them to Norma? Do I send them to
Yes,
you?
if you send them to Norma, or if you send them to the state and you include me and the state, include the state when you send that.
Mr. Martin or Mr. Garcia, or both?
You can put it to both because one of them will respond.
I just want the court to be clear on everything because I think the court had a partial picture of everything. There is some conversations about him looking at visiting that child in person with a supervision of a CPS caseworker. I have those email threads.
No, I understand. I just received an email and I want you to know the state was not included in that email. The court considers when someone is on probation, that's a contract with the court. So I received an email from probation saying, we need clarification because on the civil side, he's only allowed to have supervised telephone contact. And so maybe it was a misunderstanding on my part, but when we had the hearing, I was being told that he was being allowed contact on the CPS side. And I was like, what is CPS doing? I'm only going to agree to supervised contact. But now I discovered from that email that no, he's only allowed supervised telephone contact. So in this court, Mr. Romo, under the court's new order, you're only allowed to have supervised telephone contact with your child. You are not allowed to have any unsupervised contact with any other minor. Do you understand?
Understood. Thank you.
All right.
Judge, just to remind you, I'm sorry,
Yes.
This is Kevin. Just to remind you, the probation officer for this gentleman is actually here right now. It's Mr. Benny Puente.
All right, Mr. Puente.
Yes, ma'am.
Yes. So does the probation understand the court's ruling?
Yes, ma'am. Only supervised phone contact with a caseworker present.
Yes. Well, no, only we're going to
I'm sorry, supervised phone contact.
Yes, only supervised phone contact. If CPS has made it where he's to have supervised contact through a caseworker, then that's who he has to have the supervised phone contact through.
Yes, Your Honor.
Judge, here's what I'm going to do. I foresee it's not the first time we've had this. In the CPS case C-262, we had the same issue. So I'm going to go over there and I'm going to tell them this is what I'll even get a transcript if I need to. This is what Judge Boyd ruled today, right? So they're going to come back and say, well, we're not going to give more than what Judge Boyd ruled. And so that's what I mean about a.
No, this is what I'm telling you. I am giving him exactly what CPS is giving him. They're giving him supervised phone contact with his child. I'm ordering on this side, he's to have supervised phone contact, period. I don't understand why there would be some sort of confusion.
Because they're going to come back, Your Honor, and they're going to say, well, this is what Judge Boyd ruled. So we don't want to violate what Judge Boyd ruled. So we're only going to give.
I'm ruling exactly what they ruled, what everybody has told me. And if there's some miscommunication, everybody let me know. But what I'm understanding, and from the email that I received from probation, CPS is allowing him supervised telephone contact. Am I wrong? If I'm wrong in that,
I'm not gonna dispute that. That is 100% correct as we stand now.
okay, so that's what I'm ordering. He's Mr. Puente.
Yes, ma'am.
He is only to have supervised telephone contact. He
Understood.
is not allowed to have supervised visitation. The court ordered supervised visitation based upon what I was told in a hearing. I have learned other things now, and I'm not blaming anyone for that. I believe that everyone's officer of the court. I'm just going to say there was a miscommunication. So he is only allowed to have supervised phone contact. And I believe that supervised phone contact is with his child. So is there any question about what the court is ordering?
No, Your Honor. I'll provide what I have, and then so you can see where I was coming from. And then I will, once that changes, I'll come back over here, or I'll file another motion, and we'll just do that.
And Mr. Baila, I'm not taking that you told the court something that was untrue or deceptive. I'm just saying there probably was miscommunication all around because I didn't have the CPS caseworker wasn't here. So that's what I'm taking it as. So I don't want anyone to think that I'm saying someone's being deceptive, someone's hiding the ball. You know, this is in law school where people would hide the ball, the professors would hide the ball, and you had to find things out. I just like to have all the information. And I know I didn't have all the information, and probation didn't have all the information, and defense, you probably didn't have all the information. So now I have what I have, and what I have is he's allowed on the CPS side to have supervised phone contact. So I'm rescinding my order, giving him supervised visitation. He can only have supervised phone contact. Is there any confusion on what I'm asking for or what my order is? All right, Mr. Vela, the court is here Monday through Friday, 9 to 5. Anytime something changes on the CPS side and you want the court to hear it, all you have to do is contact Ms. Ferguson and we'll hear it.
Thank you, Your Honor.
All right, thank you. Mr. Romo, I'm going to send you to a breakout room with probation. I'm going to send you to breakout room number 1. They're going to go over whatever conditions they need to go over with you.
Thank you.
You're welcome. And Mr. Puente, thank you so much for showing up.
Yes, ma'am. Thank you.
Everybody, today is Friday. Let's keep it as a Friday. And to the clerks, could I have a B page on 2019 CR 8394, please? Okay, the next person, Jorge Aristotelides, thank you for your patience. So on Mr. Sanchez, you say you need a reset to get more information for us? All right, Kevin. On Mr. Hernandez, this is a case where we've been trying to find housing for him. And so we're going to do another 3-week reset to see where we are on that.
He's trying to find housing?
Yes, because he's not allowed to live where he's living with his parents, but yes, thank you. But previously, we spoke with a probation officer who said we'd rather for him to be there than for us not to have any knowledge of where he is. So his situation is his parents have a home in the backyard, not on the same street, but the street over, there's a school. And so far, the places that he's been asked to consider, 1, either they're not accepting someone, or 2, it's really not inhabitable. It's a slum place.
Okay.
And when I say slum place, I mean the landlord is not keeping things up. It's really shouldn't be a place where anyone's living, but nobody, hint, hint, is checking into those places to have somebody come out and inspect. So defense counsel is going to bring me some more information, and they're requesting more time to bring me more information. Is that correct, Mr. Aristotelides?
That is, Your Honor.
All right.
She assigned me to it, but then she didn't give me a thing to get in. I'm still waiting.
No, I've given you a thing. I sent you, but I'll send you again, Anthony.
Okay, thanks.
Sure, I'll send you to number 6.
Thank you.
Yeah, I don't know why people are talking and they know they're not muted. Anthony, if you have something to say to me, just say it. All
So
right.
just to clarify, we're gonna reset 3 weeks? Is that what you said?
Yes, yes, for him to get more information for me.
Thank you.
All right, and
Is there-
then
Is there
I
a
don't-
specific date, Your Honor? Just
Yes,
to
we're
check
gonna
my
get it.
calendar.
we're gonna get a date from Miss Ferguson. Miss Ferguson?
Yes, ma'am. I'm sorry. I was trying to unmute. I can do July 9th, Judge.
All right.
July 9th.
Yes,
Your Honor, that would be on a
Friday.
Friday. July 9th would be on a Friday, right?
yes.
That is correct.
That would work. What time?
Same time, 9 o'clock.
Okay, we'll do that.
All right, you and your client are excused.
Thank you, Your Honor.
You're welcome.
Have a nice rest of your weekend.
Oh, it's gonna be beautiful. You too, thanks.
I have one more question, Judge.
Yes.
Are all the Cokes in the refrigerator?
Yes,
Everything's fine. Okay.
everything's fine.
Good talking to you. Take care.
All right, you too, bye-bye. Mr. Sanchez, you're excused.
Thank you, Your Honor.
You're welcome. Number what plate? Oh, there he is. And any update on integrity unit coming in to speak with with Ms. Hahn?
Let me check on that, Judge.
All right, thank you. Benny Puente, you're back. Oh, you're on mute.
I'm sorry, am I supposed to I've already spoken with him. Was I supposed to come back or not?
Oh, no, did you give him his conditions and everything?
Yes, ma'am, everything was explained.
All right, and just have him re-sign then, that he's to have, did he re-sign conditions?
I'm gonna see him in person. I'd see him in person. I'll have him take care of it that time.
All right, thank you so much. You're excused.
Thank you.
All right, anyone else ready? All right, just give us a moment. All right, everyone, just give me 1 moment, please. Kathy Starling. Kathy Starling.
Good morning, Your Honor.
Good morning. Who do you have?
Jesse Martinez. I was trying to see if he was in the courtroom.
I don't, is there a Jesse Martinez in the courtroom?
No, Your Honor, he is not.
He is not.
Okay, let me try calling him.
All right, if you want to zoom back in at 10:30, you can.
Yes, ma'am. Thank you so much.
Sure. And Nathaniel Navy, I'm going to send you a chat.
Okay, Judge.
Again, things are moving slow. Jordan Brown. Hi, Jordan.
Hello, good morning. How you doing?
Great. I'm going to send you to breakout room number 2 with Lynn Hahn.
Great, thank you.
You're welcome.
Oh, hey, good morning, Jordan.
Good morning, Your Honor. I was a little tardy due to an email issue, but I'm here.
All right, no problem. Just give us a moment. And Norma, can you see if you can get Thomas Hilly to zoom in?
Yes, ma'am.
Thank you.
Excuse me, Your Honor.
Yes.
If at all possible, I would like to have a word for you. I'd keep it quite brief.
You'll have to wait for your attorney to come in.
Yes, ma'am.
All right, thank you.
You're welcome.
Oh, and Nathaniel Navy,
Yes, Judge.
your client, Mr. Kinnear, should be in the courtroom.
Oh, I thought based on the plea agreement, it would be okay if he was on Zoom.
Let me just see. Oh, you know what? You're right. I'm so sorry. You're right.
Okay.
He can be on Zoom.
Scared.
I didn't
Thank
see
you.
the box. I just saw that they were opposed to deferred adjudication. I didn't see the box checked for recommending community supervision. All right, John Fox.
Yes, Your Honor. It's a PTD, Judge, that we've gotten approved for. There is a upfront restitution payment that my client is ready to pay. He has to go to the bank and get the money order and all that. So the only thing I probably need to talk to Meredith again, the only issue is the exact name it needs to be made out to and the exact amount. And then if we can, I mean, certainly we can get the money paid within a week. That's not a problem. It's the question's going to be what happens with the PTD paperwork. I don't know how long that takes them. Once I get them the proof of the payment, the DA's office, then typically they're going to send me some
All right.
contract and paperwork.
When is he going to make the payment?
I can, next week, I can do that early part of next week. I don't think that's a problem.
All right, Norma, what day can we bring them back for PTD?
Give me 1 second, Judge.
And everyone, just so you know, for some reason, all the computers are working slowly. So everyone, you're really going to have to put some patience in your pocket. And I think it may end up being 100 degrees today. And I think CPS wants you to keep the thermostat on what is it, John, 90 degrees?
90, 95.
Yeah, that's all.
Whatever it takes.
July 14th, Judge.
All right, July 14th, Mr. Fox.
That's perfect, Judge. And we should have, I'm sure everything will be done by then. I can't imagine what would delay us.
All right, then
If
you and your client are excused.
Anthony, you're good to go. I'll contact you about the information. I probably need to talk with Meredith real quick once more, Judge.
All right, if you'll just go back to your previous breakout room, Mr. Fox, she'll meet you there.
I think it was 3, right?
Let me see. It was number 3. All right, Joseph Acevedo. Joseph Acevedo, you're on mute. All right, we shall see.
Just in response to that.
Yes, Joseph Acevedo, who do you have?
Decision made.
1 second, Your Honor, I'm trying to.
Sure, no problem.
Medical records.
Judge, I have William Norton.
All right, did you have a chance to confer?
Marcus was, I believe, looking at something and gonna tell me something, and then we got disconnected. I'm not sure.
I sent you a chat that the William Norton is in the 186, not this court.
And you know what, Marcus, I was just going to say, I don't see him on the docket, but you know what, Marcus, that shows how much people love coming to the 187. So Joseph, it's good seeing you.
Same here. Thank you.
All right, have a good one.
Okay.
Thanks. Bye-bye. Nathaniel, are you sure you should be here today?
I've done the same exact thing with the 186 and 187 before.
Yeah.
But no, sure I should be here.
Okay. Oh, and did you need to discuss the PSI report with your client?
I don't think so, Judge, but might as well. It doesn't hurt. I'll go into a breakout room briefly with him.
Okay, and then as soon as the court report is here, we'll take up your matter.
Thank you.
Sure, I'll send you to breakout room number 2. And Mr. Kinnear, if you go to 2. And Ms. Hahn, your client wanted to speak with me briefly, but I told him we'd wait for his attorney. But have you had a chance to confer with the state?
Judge, she has a bad connection, so we did
Sorry, Judge, was
confer.
that?
Yes. Did you have a chance to confer with the state? What is happening with your case? With the discovery? All right, I see her connection is bad.
Yes, Judge. We have a new offer with discovery.
All right, Jordan, what's happening with the discovery?
Yeah, Judge, we conferred. I made a slightly modified offer. That's good for one more setting. Discovery of the cell phone data has been turned over. There's some technical difficulties in the manner that I could turn it over. So I believe she had to get some additional equipment, a Blu-ray player to look at it. I believe she has that or is getting that shortly. So the additional setting for the plea is to give her time to look over that and to confer with the client if the court's obviously in agreement with that. That is the result of our conference.
All right, and how much time do you anticipate needing? Would 30 days be enough? Or less than that? Yes, Ms. Hahn?
I believe so. Unavailable July 11th through the 18th. But anytime after that, I think would be.
All right, Norma, can you recall this for the week of July 11th?
Yes, ma'am. I can do that Monday, the 12th or the 14th.
All right, Ms. Hahn, 12th or 14th?
Which is a Monday or Wednesday.
I will be out of town for both of those dates.
I think she broke up. I think she was saying she was not available from the 11th.
Oh, okay, because I was like, oh. All right, Norma, do it the week of July 19th.
I can do the 21st.
July 21st?
That'd be perfect.
All right, so July 21st, then that will be your plea deadline date, Ms. Hahn. So Mr. Bueno, the court will not accept any plea bargain agreements after that date. Do you understand?
Thank you.
All right, and Mr.
Yes, I can, ma'am.
All right, Mr. Bueno, you have your attorney's information, so you can always get in touch with her, okay?
Yes, ma'am. Thank you.
All right, thank you so much for coming. Have a great rest of your day.
I was hoping I could have a word, ma'am.
What word would you like to have?
It's just a simple plea with you.
Mr. Bueno, I would not advise that at this point.
Okay.
All right, your attorney, here's the thing, Mr. Bueno, your attorney knows more about your case than I do. The state knows more about your case than I do. So far, the only thing I know is what you're charged with. So your attorney may not want you to discuss certain things with me just yet.
I understand, ma'am. It's just a simple plea to urge an amicable outcome to this.
Oh, no. That's something you'll need to discuss with your attorney, okay?
Yes, ma'am. You have a great day, weekend.
All right, thank you.
Yes, ma'am.
Thank you. Let me see.
Thank you, Judge. Have a nice weekend.
Thank you. You too.
Thank you,
have a great
Jordan.
weekend. Thomas Hilly, you are here on Robbie Rojas. So I'm going to send you to a breakout room. And I see yes.
I have a lot of other Zooms this morning, and all it is a SafeP question about SafeP. So we just can proceed on that. There's no need to confer, because I think that we already did all the plea and all the sentencing. We just need to figure out whether or not he can go to SafeP.
Norma, is that what we're here for?
Yes, she wanted to know the status of safety, Judge.
Okay. Kevin
Yes.
Hernandez, do you know the status of safety for Mr.?
I was looking at it. Yes, I was looking at it. He met the criteria. They should be picking him up pretty soon. They're on the list. He had to they got approval on the 17th last month. So he should be in within the next couple of weeks.
All right, so he was approved
Yes, I have.
May 17th.
Yes. They put on there, met the criteria for safety.
And he should be transferred in 2 weeks.
Give or take.
Okay, then you are, do you have anyone else with us, Mr. Healy?
Well, I appreciate you and I apologize for being late. I just didn't. Thank you so much.
No problem. Thank you.
Bye-bye.
Bye-bye.
Judge, so I can tell them they don't need to bring him out then? Judge?
No, they don't need to bring him out.
Okay, thank you.
Thank you. And then next, we're going to take up Nathaniel Navy's case. Brenda, is it super hot outside?
Yes.
Okay. All right, we're going to take up Nathaniel Navy in just 1 second. Bob Behrens, who do you have?
Judge, we recall Jason Townsend for today. I haven't received any links for paperwork yet.
All right, is it criminal trial division?
Yes, I guess I need to speak with Mr. Townsend. We had alternate offers available and he was leaning towards one, but wanted to talk to somebody overnight, so.
All right, Mr. Townsend, I'm going to send you to breakout room number 3 with your attorney. And then Bob, if you'll come back and let us know what the results are.
All right.
And then Nathaniel Navy, are you ready? There you are. Let me see if we have a prosecutor. Is there a prosecutor available for Nathaniel Navy's case?
Marcus?
Pretty typical for my dad.
Mr. Kadir, I need you to show your video. Thank you. Kevin, could you forward me his PSI report, please?
Mr. Kinnears?
Yes.
Sure.
Thank you.
And Judge, I was also planning on offering 2 exhibits, Defendants Exhibit 1 and 2. I sent that to Brenna, the court reporter, and then also Norma and Marcus. I don't think that the state's going to have any objection to that. So if you want to review those as well.
Yes, Marcus, could you forward those to me and include Mr. Navy in the email?
I can do it, Judge. I was the one to send. I can send it to you real quick.
All right, thank you. Okay, and I'm just waiting to receive it. Okay, I've read the PSI report and I did read the exhibit. Court is calling 2020 CR 2060 State of Texas versus Kirk Kinnear. Can I have the parties announced for the record for the state,
Marcus Sanders.
for the defense?
Nathaniel Navy.
And are you Mr. Kirk Kinnear?
Yes, Your Honor.
We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No objection, Your Honor.
Mr. Kinnear, do you have any objections to us proceeding by video?
No, Your Honor.
And the court will note for the record that the defendant entered his plea on May 7, 2021, and he entered that plea by video, and there were no objections at that time. The defendant entered a plea of no contest. The court found there was sufficient evidence of guilt. The court deferred finding of guilt as the defendant had applied for deferred adjudication. According to the plea bargaining agreement, punishment is to be assessed at 5 years in the prison. The state is opposing your application for deferred, but they're recommending your application for community supervision. Have both parties had a chance to review the PSI report?
Yes, Your Honor. I did
Any-
review it and I don't have any objections to it.
All right, state, any objections to the PSI report?
No, Judge.
All right, the state is in agreement with community supervision, not in agreement with deferred adjudication. State?
Yes, Judge, we're opposed to deferred in this situation just based on the facts of the case that our victim was blindsided and attacked without any sort of provocation, and the lasting effects that it's had on him. In the PSI state, not only does he have medical expenses, but that he still suffers psychological issues from the assault. Mr. Nair he doesn't have any serious history, but he has been given chances on deferred before, as you can see from his out-of-county history. And so we felt that probation in this situation, because the offense allegedly happened partially due to intoxication and not necessarily ill will, we felt that probation was appropriate, but not deferred.
All right, defense?
Yes, Judge. Obviously, we know that the facts of this case are severe. My client's not trying to, provide any sort of excuse for the court. There is no good excuse for a case with these kind of facts, Judge. My client has tried to rectify that behavior, which stemmed from extreme alcohol consumption, and he was under heavy influence of alcohol that day. He did take an anger management course, Judge. That's Defendant's Exhibit 1 for your consideration. And then Defendant's Exhibit number 2, this was something that he brought up to me. I did not have to prompt him for this, Judge. He just wanted to write a letter of apology to the victim in this case to apologize for what he did. Obviously, there's a no contact order, so he can't reach out to him or anything like that. But I provided this as an exhibit, and if there's any way for the state or the probation department to see that the victim in this case does receive that, Mr. Kinnear would appreciate it. And from reading the PSI, I understand that the victim gracefully was not requesting any sort of prison, just that Mr. Kinnear get help for whatever trigger there was, just to be sure he doesn't do something like this to anybody again. And it's something that my client regrets very deeply. He wants to make sure he doesn't do anything like this to anybody again. He just wants to be the best person that he can be going forward, Judge. He's obviously exposing himself potentially to more prison time. He understands that if you were to grant the deferred adjudication, because you'd have the full range of punishment. But I believe if you do give him this opportunity, Judge, that he's going to take it very seriously. Whatever requirements that you require him to do, he's going to do those. He works as a contractor currently. He has 3 young children. He wants to set a good example to them, to not act out in this manner in any way in front of them, of course. He doesn't have any felony convictions, and in fact, no felony arrests. This was his first felony arrest. And like Mr. Sanders said, though he does have a number of misdemeanors, I believe that there was only one that's been a conviction, and one that he received deferred adjudication on. And so even though there are a few arrests, Judge, there was only one conviction on those. So I believe if you give him this opportunity to complete deferred adjudication, he'll take it very seriously, Judge, and do his best to be a better person from this day going forward.
All right, off the record for a moment. Carl Alexander, if you could go to breakout room number 2, your client is in breakout room number 2.
Judge, I've yet to receive the plea paperwork. The only thing I've gotten is a discovery acknowledgement, which I
Oh, we're
just-
working on it, Judge. I'll go to
All right.
breakout room.
Do you need a breakout room with Mr. Alexander?
I don't believe so, Judge, but I'm happy to talk with him.
All right, then Carl, I'll see you to number 1. And then after you're finished, if you'll just send me a chat and I'll make sure you get to number 2. And Norma, if you could go to number 1 and see what paperwork they need.
Thank you, Judge.
All right, is there anything else from either side?
No, Your Honor.
No, Judge.
All right, Mr. Kinnear, is there anything you wish to say?
No, Your Honor.
All right, well, I have a few questions for you, Mr. Kinnear. If you're drug tested today, what are the results going to be? And know that you are going to get a drug test today.
I will be honest with you, Your Honor. I will be positive for THC.
And what else?
That's it.
All right, why would you take a chance on being positive when you know that I'm about to make a decision on whether or not you should get deferred adjudication or regular probation, or perhaps say I'm not following this agreement? Why do you take THC? What's going on?
Really, honestly, I use it for back pain, but I don't want to sit here and give you any excuses. If I get deferred today, I will not fail another drug test.
All right, but I'm trying to get to the point. I haven't seen, and people say THC, maybe it helps with pain. How were you taking this THC?
How was I taking it?
Yes, I mean, are you doing a tablet? Is it
No,
cream?
yeah, I just smoked it.
Okay, I've never heard of people smoking marijuana and that being an answer for pain. I've heard of it maybe leveling you out for other things. So when's the last time you had alcohol?
Alcohol, the day of that arrest.
All right, have you had any alcohol since?
No, Your Honor.
All right, do you have any tattoos?
Yes, Your Honor.
What's up with the tattoo?
I'm sorry, which one?
The one that's on your forehead, or am I seeing things incorrectly?
No, ma'am. Yes, that's my wife's name.
All right, so Brenna, these are questions that I have. Do people have memory problems where they must tattoo people's names on their forehead in order to remember? So what possessed you? I don't want to say possessed. What caused you to get a tattoo of your wife's name on your forehead?
I don't know, Your Honor. It was a random, spontaneous thing I did a few years back.
Are you still together?
Yes, Your Honor. It's the mother of my children.
Well, I mean, some people get tattoos of names of people on their face and then they're not still together, which makes it awkward if you're in a new relationship.
Yeah.
So what are you doing for employment?
Right now I'm on unemployment, but I'm a project manager for a contracting company and we're about to break loose on some work. It's looking like in about 2 weeks, we're going to start a bathroom remodel and they're just going to keep coming after that. The church has a bunch of work for us and members within the church as well.
All right, so where's your anger stemming from?
I believe it's just alcohol does that to me. I'm a violent alcoholic, I guess.
No, because here's the thing. People always say, I don't know if this is true because I don't drink. I just don't drink because I think it tastes nasty. So, but people say that really, when you're under the influence, you wouldn't do anything that you wouldn't do if you were not under the influence. So I'm thinking the anger has to come somewhere. And if you don't know where that anger comes from, then it's going to repeat itself. And my job, even though I know that the state has agreed for your having probation, my job is to make sure that I give you conditions, protect the community, but make sure you're rehabilitated. So I'm trying to figure out where this anger is coming from.
Yeah, and I took a anger management course, and I'm thinking, after doing that anger management course, I was bullied a bit when I was a kid. You know, I had kind of a lot of people bullying me in elementary school, and I'm thinking that's probably the stem of the anger. Honestly,
You're holding on to stuff from elementary school.
that's what
I mean, some people do. I mean, but at some point you got to let that go.
I think so. Yes, maybe.
Unless you're gonna call up some former 5-year-olds. Are people 5 when they're in elementary, Brenna? 5 and like 5, 4, 6 or something? Okay. All right. If there is, one final thing. So here's the choices for you, Mr. Kinnear. You know you better than I know you, better than the state knows you, better than your defense attorney knows you. Because sometimes people only present what they want people to see. Sort of like when you have a first date, as some comedian said, you're not meeting that person, you're meeting their publicist. So I want you to dig deep inside yourself and tell me, do you think you can successfully complete probation?
Yes, Your Honor, I'm 100% sure I can. I have 3 toddlers that rely on me to be there, and I would never want to be out of their lives.
So then this is where we are. I can give you deferred adjudication. I've read what the complainant says, and that's very nice of the complainant to say, I don't want Mr. Kinnear going to prison. I just want him to get help. That's great of him. So this is where you are, and I know your attorney said he spoke with you about this. I can give you deferred adjudication. If you were revoked, you could possibly end up getting 20 years in prison. The offer that the state has tendered you, if you were to get revoked, the most that you can get would be 5 years. So I'm going to give you a choice. Sometimes I can't give people choices. Do you want deferred adjudication? Where? Or do you want regular probation?
I would like to get this behind me, get it off of my record, and just move on with it.
Well, your attorney will probably speak to you about that, but this is going to be on your record.
Okay.
Deferred or regular.
Okay.
I mean, if you successfully complete everything, it will show up as being dismissed, but it will be on your record and it will show that you received deferred adjudication for this.
Okay, Your Honor.
So do you want deferred adjudication or do you want regular probation?
I want deferred adjudication, Your Honor.
All right. I'm gonna send it to you to 8 years deferred adjudication, $2,000 fine. That'll be probated. No contact with Jeffrey Schauberger, Schauberger, 100 hours community service restitution, or you can pay $7.25 per hour to the food bank. Proof of employment within 30 days. No employment with vulnerable persons. What that means is you can't be employed as a home health care provider or any job that involves supervision of minors, parenting classes. I'm going to want UAs, tests for levels. And if there's an increase in his levels, then I want to know about it. I'm going to want random field visits 2 times per month. There'll be regular Zoom reporting or in person. So what that means, Mr. Kinnear, if something happens where you can't Zoom, you're going to have to report in person.
Yes, Your Honor.
And then I see that there is some restitution. Have both parties had a chance to review that?
I did, Judge, and it looks like it's undetermined at this time. I think that the victim didn't have his medical bills at the time, and it was just he needed time to gather those.
Okay, so this is what I'm going to do. I'm going to do restitution, if any. If probation can reach out to the complainant and find out what his restitution is, in defense, if there are any objections to the restitution amount, we can have a restitution hearing. So there'll be restitution to Jeffrey Scharberger, if any. Going to do anger management. And Kevin, he supplied the court with a certificate of anger management. That'll be acceptable. Kevin, is there anything else that he needs?
No, Judge, I think we got it.
Mr.
Judges.
Kinnear? Yes.
There is one thing, he lives in the Houston area. If we could transfer him to Harris County.
All right, I'll do a transfer to Harris County. And Mr. Kinnear, you're not transferred to Harris County until probation tells you you're transferred, okay?
Yes, Your Honor.
Mr. Kinnear, is there anything else you need from the court in order to be successful?
No, Your Honor.
All right, Mr. Kinnear, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you electronically sign it?
Yes, Your Honor.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
All right, we can go off the record, Mr. Kinnear. You're very lucky. You're lucky for two things. One, nobody died. Two, that complainant showed mercy towards you and stated that they did not want you to go to prison. So you need to pay it forward and be a better person. You need everything you do from here on out, you need to ask yourself, is this a decision that could result in me going to prison for 20 years? You understand?
Yes, Your Honor.
All right, and here's the thing, I tell everybody this, and Nathaniel, he's like a permanent guest here in the 187. He can tell you I say this. I usually say it as it relates to relationships, but if you really want to see if you have your anger under control, buy an orchid. They're usually like what, $12 maybe, or $7.99, and keep that orchid alive for a year, because orchids take a lot of patience, and sometimes you're waiting for a flower to bloom and it never happens, but you keep going with it. All right.
Yes, Your Honor.
Okay, I'm going to send you to a breakout room with probation. I'm going to send you all to breakout room number 5. And Nathaniel, you can go to 5 with your client if you so choose. And after that, you are excused.
Thank you,
And you
Judge.
all can be excused from the breakout room. You're welcome. And Kevin, I think you have the ability to go to 5. If not, I'll send you there.
Yeah, I don't, Judge.
Okay. I don't know why. I guess we need some sort of update so that everybody can have everything.
And Judge, I can do a chat, Judge,
Okay.
please.
All right, Mr. Norton. William Norton.
I don't think he can hear you, Judge.
Okay, let me chat him.
I think he's having issues with his audio. He's just nodding his head. He can hear you, but he can't. Yeah, he can hear you, but he can't respond.
All right, Mr. Norton, you need to be in the 186 District Court. We're going to let them know that that's where you should be. And we're going to let them know that you're having problems with your Zoom capabilities. Norma,
Joseph Acevedo, yeah, Joseph Acevedo is the attorney.
Okay, and he's already left. Could you send a message to the 186 and let them know that Mr. Norton is here and he's having difficulties?
Yes, ma'am.
All right, Mr. Norton, if there's any problems with the 186 because you're late, just have them to call the 187, then I'll let them know you were here. If you hear me, give me the thumbs up. Okay, I think he hears me. He's nodding. All right, Jonathan Watkins.
Can you hear me, Judge?
Yes, I can.
Good morning, Your Honor.
Good morning.
In-person proceeding in a different county. I have Michael Moreno. It's a motion to set bond, and then I have Obed Urdiales, and that's a motion to modify or amend conditions of bond. Mr. Moreno's case is a family violence case, and for Urdiales, a trial division.
Okay, what I'm going to do is I'm going to send you to a breakout room. And I'll let CTD and family violence know that you need them.
Thank you.
Judge, I'm here for family violence. We don't need to confer on anything due to the nature of his cases. We're going to ask that he be remanded without bond and continue that way.
Judge David, the complainant's been reaching out to me. Apparently she's been trying to reach the office. So,
okay, we're still going to ask that he be remanded without bond and stay that way.
Okay, so this is what we'll do, Mr. Watkins and Mr. Moreno, because I don't lift remand without bonds or any of that until I have all the evidence before me and hear from people. And I don't like lifting that when I haven't heard from the complainant. So I wouldn't know enough information or have enough information to lift the remand without bond. So if you want to set that, and we can have, if the complainant wants to zoom in, you say the complainant is trying to get in touch, you can have the complainant zoom in. But here's the thing, if the complainant is going to come on to this Zoom and say that this is untrue, then she'll need to have an attorney appointed to her.
Your Honor, I anticipate that happening to be from what I've tried to keep my hands off of this, and I've referred her to contact Mr. Martin and Mr. Garcia. But I anticipate that occurring.
All right, so this is what we'll do. We'll reset it for a hearing. If the complainant wants to be here, the complainant can be here, and we'll make sure that she has an attorney.
And is there any availability next week, Judge? Just because he's been in custody for over a month now.
Yes, there will be availability.
Judge, I just send you a chat.
Yes, I see that. All right, who is V. Marino?
He's in custody, Judge.
No. Norma told me there's a V. Marino on the Zoom. So I don't know if that's the complainant or not. All right, so what we'll do, Ms. Ferguson, if we can bring them back next week. All right, we're going to get a date for next week.
Yes, ma'am.
You're on mute.
I can do Wednesday, Judge.
All right, is that going to be at 2?
Yes, we'll do it at 2, Judge.
All right, we will see you on June 16th at 2 p.m. I'm sorry, not 16th. We're in the 18th, right? We're going to see you June 23rd.
And that's for Mr. Moreno, Your Honor.
That's for Mr. Moreno.
Yes.
And we'll
yes,
have a hearing if you can, and you'll receive the link. And if the complainant wants to zoom in, she can zoom in. And if she needs an attorney appointed to her, we'll make sure that happens.
Yes, I'll forward her the link once I get it from Norma.
Thank you. Mr. Marino, we're going to be back for your case on June 23rd. All right, Mr. Marino, can you unmute, please? Press the space bar. It's the longest key on the keyboard.
Judge, I sent you a chat.
There you go, ma'am.
All right, Mr. Marino, I see that you're probably like in your feelings right now, but here's the thing. You can be in your feelings right now and I can hear this matter and continue to remand you without bond, or you can wait for your counsel to have witnesses here and I can listen to them. So it's your choice.
I'm fine with it, ma'am.
All right, thank you.
In Jesus' name, I'm fine with it. Thank you.
Thank you. You're welcome. So we're going to bring you back on June 23rd. Norma, can you let them know that 14-0 can go back?
Thank you.
All right. You're welcome.
You have a blessed day, ma'am. Thank you.
Thank you. You have a blessed day too. All right. Then we have Mr. Yuri Dallas, and that's a motion to amend bond conditions. Hi, Mr. Yuri Dallas. Who is able to confer with Jonathan on this?
Judge, I don't want to seem like no one wants to talk with Watkins, but we've been here on this motion a few times before and our position is still the same. So we don't need to confer unless there's something Watkins thinks we need to.
Okay, let me see what's being asked for. Oh, just 1 second, Mr. Watkins. I'm reading your motion. Yes, Mr. Behrens, what is happening with Jason Townsend?
Oh, I was just about to chat Tom. He's going to take the two-year offer, Tom.
Okay, all right. What, Bob, wait, I think I have your email.
Or it's just our Barron's Law.
Our Barron's. Yeah.
Yeah. So those cases are gonna get resolved, Your Honor.
Okay, we'll
All
start
right,
the
thank you.
paperwork, okay?
Yes, and Judge, while he's doing that, can I go to the 186?
Yes.
Okay, thank you.
All right. So, Mr. Watkins.
Yes, ma'am.
Okay, I'm reading your motion. What are the issues with him being on GPS? Other than that he's been on GPS, because I'm allowing him to work.
Yes, ma'am.
All right, so I'm trying to figure out what the issues are.
Judge, he's just having a little bit of harm. He is allowed to work. If the court's not okay with outright removal, what I'm respectfully requesting is tracking only. He's been for 9 months now. There haven't been any violations. He has no prior violent record at all, or no prior convictions at all. And there's been a little bit, given the nature of his work, Judge, what he does for a living and just his mobility. So specifically, Judge, he's used to attending conferences in the summer that are like networking conferences. And he's really just anxious about that. There are some family activities that
Okay, but Mr. Watkins, I've allowed him to, if he has conferences to go to for work, the court is allowing him to go to work-related events. I thought I made that clear in my motion. I mean, in my ruling.
if Judge, I guess what I'm asking for, if there's no way the court is willing to do a removal, we could just do traffic.
All right, just state are you going to have any objections to tracking?
No, Judge, that's fine.
All right, Mr. Uridalis, we're going to do tracking. So that means that you can
Yes, ma'am.
do what you need to do. So it'll be tracking only, okay?
Of course. Thank you so much, and I appreciate everything.
All right, you're welcome.
Thank you.
And it is Friday.
Yeah, oh, thank you. Yes, it is. All right, if you don't
A
have
good
anything-
Friday.
Yes.
It's a great Friday.
It is. Jonathan Watkins, if you don't have anything else with us, then you're excused.
Thank you, Your Honor, and thank you.
All right, thank you.
Thank you, Your Honor. You have a wonderful weekend.
Thank you, you too.
Thank you.
Okay. Is there anything else that's ready from anyone? Carl Alexander, you're back.
Yes, ma'am. I sent you a message as requested, but so I've gotten all the paperwork now from both Norma and from Hunter, but I was wondering if you can enable screen share. That way I can actually go over it with my client.
Is your client in the Zoom room right now, in this main room?
I think you have him in a waiting room, not a waiting room, in the breakout room.
Okay, so this is what I've discovered. If I hit share screen now, he won't be able to see anything. So he'll have to come back to this room. And then I'll hit share screen and then everything will work fine.
Okay. I'm not sure which breakout room he's in because I know I went into.
Let me see. He's in 2. Let me just do this. Norma, can you have them help Mr. Balsadua with the share screen, please?
Yes, ma'am.
All right, so he's in 2. I sent you to 2. We'll see what happens.
Okay, thanks, Judge.
Todd McCray.
Good morning, Your Honor. I believe we've worked out our motion by agreement. I'm in the process of emailing you, Tom, and the clerk with that agreement, the proposed agreement.
Okay, thank you.
If I could get the clerk to chat me the email address, clerk's email address, I would appreciate it.
All right, to the clerks, could you chat Mr. McCray your email address, please?
Yes, Judge.
Thank you. And everyone, give me a moment. Anthony Cantrell, you're back.
Yes, Your Honor. We have an agreement on this case. I need to relay that offer to my client. And at some point, we'd like to have a conversation with you, I think, between Tom and myself.
Well, do we want to have the conversation with me first?
Sure. Yes, I don't have a problem with that.
All right, so Mr. Cantrell, I'm going to send you to breakout room number 1. And Mr. Nesbitt, if you go to 1.
Your Honor, you should have the email with our proposed agreement.
Mine is saying 4. Can someone switch me to 1? Two?
Everyone, just give me a moment, please. I'm checking document. All right, Mr. McCray, the court is in receipt of your agreement with the state. And so I'll follow your agreement that's been reached with the state. Is
Thank
there
you.
anything else with your client today?
No, Your Honor, we appreciate the court and Mr. Nisbet. Can we be excused, please?
Yes, you can be excused.
Thank you. Two other courts on a Friday Zoom, Judge.
Okay, well, you have a great rest of your Friday.
Thank you, Judge.
You're welcome.
Thank you, Judge.
All right, you're welcome. I'm sorry? No, I've already printed it out. Thank you, though. Does anyone have an update on Brent Coffey and his client Stephen Garza and whether they entered the plea and misdemeanor court?
I do not, but I can look into it, Judge.
All right, thank you.
Meredith has something.
I do, Judge. I'm going to be submitting a dismissal.
All right, thank you. All right, and I believe with Kathy Starling's client, I guess he's not going to appear. And I believe there's a warrant already out for Mr. Martinez, is that correct?
Yes, ma'am.
Tom,
Yes, Your Honor.
hi, so on this case, this agreement that you have with McCray, it's to remove the GPS?
Yes.
Okay,
Basically, he has been earning his way towards that over the last calendar year.
oh, no problem. The way it was written by Todd, it just seems like it's removed GPS tracking. That's all he said instead of removing GPS.
He was full, then he worked his way to partial, then he worked his way to tracking. Now he's worked his way to removal.
Okay. Everyone, the court is breaking at 12, so if everyone has their paperwork, you need to get it to the court.
Judge, I just submitted mine, so I guess it's going over to Mr. Townsend, or it should be.
All right, Norma, can you let the deputy know that Mr. Townsend has paperwork?
Yes, ma'am.
And Mr. Barron, so I'm going to send you and your client to breakout room number 1.
Hopefully screen sharing will work.
Yes. All right, and what is happening with Mr. Balsadua?
Judge, we just completed the paperwork, so it should be, we both sign it, so it should be on its way to the next.
All right, to the clerks, there should be paperwork coming to you on Mr. Balsadua.
Thank you, Judge.
I just signed it, Judge.
All right, thank you. Mr. Balsadua, I'm going to send you to a breakout room number 2. I'm sorry, number 3. The clerks will swear you in.
Okay, thank you.
You're welcome.
He just needs help getting back in here, Judge, but Mr. Buzzledua is sworn in.
Okay, awesome. Norma, can you let them know that Mr. Balsadua needs help being brought back to the main room?
Yes, ma'am.
Thank you. Who are the prosecutor on this?
It's Hunter Morris, Judge.
Hey, Hunter. Brenda, there are two people on the screen today who are wearing plaid.
Marcus is too, I think.
Oh my goodness. Okay, this is a Sesame Street moment.
He is like,
But if we look at heads, it'd be like one of these things is not like the other.
yeah. So it's like a Sesame Street moment though, where it's like you get up in the morning, you have to decide which one is not like the other. But oh gosh. Well, Brent, I think you and I would be kicked out. Court is calling 2021 CR 2774, State of Texas versus Raimundo Balsadua. Could I have parties announced for the record for the state?
Hunter Morris for the state.
For the defense?
Carl Alexander for Mr. Buzzledua.
And are you Mr. Balsadua?
Yes, ma'am.
We're proceeding by video because of the pandemic. Any objections from the state?
None, Judge.
Any objections from the defense?
No, Your Honor.
Mr. Balsadua, I'm going to show you a document entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Next, I'm showing you what's entitled Application for Community Supervision. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case? And did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Balsadua, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Proceeding on count 2, Judge, leaving the remaining counts and the deadly weapon in this case. I don't believe there is any enhancements, Judge, so count 2.
All right. Any objections?
No, Your Honor.
No.
All right, Mr. Balsadua, I'm showing you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
What you're charged with in count 2 is possession of controlled substance, penalty group 1, 1 gram to 4 grams. That is a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement you were giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent but was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Balsadua, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than a plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived his right to jury trial. Next, I'm going to show you what's entitled plea bargain agreement. You review that page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, the state is proceeding on count 2. Punishment is to be assessed at 2 years in the prison. There's a $1,500 fine. that will be probated. State recommends community supervision. They will take in consideration 2020 CR 10204A, 2021 CR 2773. There's restitution of $57 to San Antonio Police Department for laboratory testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
State, is that the plea bargain agreement?
Yes, Judge.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
Just one moment, everyone. I'm signing a document. Next, I'm going to show you what's entitled waiver of appeal. Did you review that paragraph with your attorney? Did you understand it? And did you electronically sign it in both places?
Yes, ma'am.
Do you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have any such motion?
Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 2 years. There be 120 hours of community service restitution, a TAP evaluation, no contact with Esmeralda Martinez, the Camino Real Motel at 623 East Bonner, Bonner Avenue, San Antonio, Texas, 78214, and screening for adult drug court. And what I can tell everyone is there is a waiting list for adult drug court. So I will put him on the waiting list if I deem it necessary. So did you understand, Mr. Balsadua, that the court did not have to follow that? Those were just recommendations from the state. Did you understand?
Yes, ma'am.
As of right now.
Then to the offense is charged in count 2. How do you plead? Guilty, not guilty, or no contest?
I'm guilty.
State any evidence to support the defendant's guilty plea?
State upper states one of the attachments, Judge.
Any objections?
So hers is gonna be 210.
All right, Mr. Balsadua, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront witnesses the state will call, and the right to remain silent? Did you understand?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
The court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence states exhibits 1 and attachments, and the court will review the same.
Quería saber qué es lo que estaba pasando conmigo. Well, today is Wednesday, right? Oh, today's Friday. Today's Friday.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, ma'am.
Is there anything you wish to say on behalf of your client?
Your Honor, I've discussed the cases with Mr. Balsadua, and as I'm sure you have surmised, he's suffering from an addiction problem. He's indicated to me that he is motivated. We had a long discussion about if he should even apply for the drug court program because I didn't want to take away a seat from someone who was serious and who was motivated to actually achieve recovery. He's indicated to me that he is ready to actually better his life and to quit coming back into the system and to do right by his child. So we're just asking that you follow the plea bargain agreement, that you put him on community supervision for 2 years, and that he be released so that he can get back to his family and start showing you that he can be successful on this.
All right, Mr. Basadua, who is Esmeralda Martinez to you?
She was my ex. She's my ex-girlfriend.
All right, do you have any connections to her other than she's your ex-girlfriend?
No, ma'am.
You all don't have any children together?
No, ma'am.
How old is your child?
My son is 5, going on 6. My daughter's 3, going on 4.
And where are they now?
They're with their mother.
So how often were you using drugs?
I was using them daily.
And what were you using?
I was using meth, crystal meth.
How far did you go in school?
I graduated. I graduated from high school.
All right, what are you planning on doing with the rest of your life?
I'm planning on getting a good job and taking care of my children.
Okay.
Getting my family back.
Okay. So is the last time you used before you were taken into custody?
Yes, ma'am.
All right, this is what the court is going to do. Court's going to follow your agreement, sentence you to 2 years in the prison, suspended and probated for 2 years, $1,500 fine, probated. Take in consideration 2020 CR 10204A, 2021 CR 2773, $57 to the San Antonio Police Department for testing. No contact with Esmeralda Martinez, Camino Real Motel at 623 Sparta, San Antonio, Texas 78214. The 120 hours of community service restitution, either he can do that, or if he completes or obtains some sort of certificate from a trade school, or if he completes some higher level of education, the court will accept that in exchange for community service hours. However, the court will not allow him to buy out his community service hours. I'm going to, Kevin, if you could you let felony drug court know this is an emergency and see if they are able to place him somewhere? I'm going to put him on the waiting list for felony drug court. But what I'm going to do, Mr. Balsadillo, I'm going to refer you to ISF substance abuse track. Felony drug court may be able to get to you before then. I'm putting in a 911 call through Kevin Hernandez to see if they can get you into the program, okay?
Okay, thank you.
I know you're probably going to be like, curses, I thought I was getting out of jail today, but truly I'm trying to do what's best for you so that you can be there for your family and not be there, under the influence, okay?
Okay.
Carl, what we'll do is we'll reset this so that I'll know and we won't lose track of him in the system. We'll give him a reset date to see where we are on either transfer to ISF or going to felony drug court.
So just to clarify then, so then you want me to refer him to felony drug court first?
Yes, and tell them 911. See if they can.
I mean, I will, but I'll see how that goes.
All right, thank you. We're going to do proof of employment within 30 days of release from custody. Going to do random field visits 3 times per month. We'll do the UA hotline once he's released. And if I didn't say it, yes, I did say parenting classes. Kevin, is there anything else? We'll do regular reporting, either Zoom or in person. Kevin, is there anything else he needs?
No, Judge, I think we got it.
All right, Mr. Basadou, is there anything else you need to help you be successful at this probation?
No, ma'am, that's pretty much it.
All right,
So
Mr.
I'm just gonna be waiting for
For
the drug
transfer.
to
Yeah, either
transfer.
for felony drug court or either transfer to inpatient treatment at ISF, okay?
Okay, and I'll be waiting in here.
Yes.
Okay.
All right, I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
Norma, Mr. Bossadua, can we have a 3-week reset, please?
Yes, ma'am. I can bring it back on the July the 9th. It's on a Friday, Judge.
Okay. All right. We're going to come back on July 9th, Mr. Bossadua, to see where we are with your transfer, okay?
Okay, and I will be waiting in here, like you said.
Yes.
Okay.
All right. We're going to go off the record, Mr. Bossadua. Here's the thing. If you violate your probation, there's a chance you could go to prison for 2 years. But even more important than that for you is if you violate your probation, there's a chance that you are not going to be in your children's life at all. You need to work on being a role model for them, okay?
Yes, ma'am.
It's not too late.
Yes, ma'am. Okay. Thank you so much.
All right, you're welcome. I'm going to send you to breakout room number 2. Carl, I'll send you to number 2. And Kevin, if you can go to breakout room number 2, let me see where you are. To go
Sent you a
over.
chat too. You can take a look at that real quick.
Oh, let me see your chat. Oh, sure. Let me give you the address. It's 623 East Bonner, B-O-N-N-R, San Antonio, Texas, 78214. Okay, everyone, if you'll go to breakout room number 2.
And 2 things just before I do
Yes.
that, and maybe excuse from the breakout room when we're done.
Yes, yes.
I almost wore a black shirt today, and then I would have matched you and Kevin.
See, what were you thinking?
But still, I would have been the one thing, not like the others with the hair. You know? And,
All right.
although it was delayed 4 days, the first firm official Fiesta medal is in. So I need to know how many to bring down to the court.
Okay, well, I don't have one, so, you know.
I don't expect anything in return. I just like to share the love.
I know, but I'm saying I don't have one. Nobody brought me one.
Well, they literally came in while I was here in the hearing. Like FedEx.
Oh, okay. All right. Well, I have my Fiesta medals as well. I think somebody should do a Fiesta medal wreath. I think that would be so beautiful with all the different colors. Well, I hope everybody is going to have a safe and happy Fiesta.
Yes.
Carl, Deputy Lauer wants 2 of them.
Okay. Well, we're going to try to make it down either today or early next week, but I hope everyone has a wonderful weekend.
All right. Thank you. You too. Mr. Bossadua, you need to go to breakout room number 2.
Okay, thank you. You have a good weekend.
All right. Thank you. You too.
Judge, I'm back. I think all our paperwork should be ready on Mr. Townsend.
Okay. I'm just waiting for the clerks to give that to me.
All right.
Judge,
Yes.
can you put me in the breakout room with Townsend because he got out.
All right, Mr. Townsend, you need to go back to the breakout room so you can be sworn in. I'm sending you to breakout room number 3. Tell them you need to go to number 2, Mr. Bossadua. Yeah, he went there. Mr. Norman, can you have them send Mr. Townsend to breakout room number 3, please?
Yes, ma'am. They're on their way, Judge.
Thank you.
Judge, I send you a chat.
Okay. Oh, no, Norma, you can start now.
Okay, thank you, Judge.
Thank you.
Judge, did you want me to go back to a breakout room with Mr. Townsend for something?
Oh, no, Mr. Townsend is just being sworn in. He left the
Oh,
room
okay.
too
I got
quickly.
it. No worries.
Brenda, are you ready?
Yes, Judge.
Okay, and we're doing 2. Mr. Townsend, can you unmute for me, please?
Ma'am?
Thank you. Court is calling 2021 CR 3942 and 2021 CR 1793, State of Texas versus Jason Christopher Townsend. Can I have the parties announced for the record, please, for the state,
Marcus Sanders.
for the defense? For the defense.
Sorry, Robert Barons for Mr. Townsend.
No problem. We're proceeding by video because of the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Townsend, the court is showing you what's entitled defendant's consent to appear by video. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you electronically sign it?
Yes, ma'am.
Then in each of the cause numbers, the court will find that the defendant has knowingly and voluntarily consented to appear by video. Counsel, in each of the cause numbers, I'm showing you the discovery acknowledgement. Have you received all the discovery from the state, and did you review that discovery with your client?
I have, Your Honor, and we reviewed it yesterday.
In each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Townsend, in each of the cause numbers, I'm showing you what's entitled true bill of indictment. Did you review those documents with your attorney, and did you understand them?
Yes, I did, ma'am, and I understood.
Counsel, do you waive the reading of the indictment in each of the cause numbers?
We do, Your Honor.
State in cause number 2021 CR 3942, are you proceeding on the indictment as presented?
No, Judge, we're waiving the enhancement paragraph.
Any objections?
No, Your Honor.
And in cause number 2021 CR 1793, are you proceeding on the indictment as presented?
Yes, we are.
Mr. Townsend, in each of these cause numbers, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review those documents with your attorney? Did you understand them? And did you electronically sign them in all the appropriate places?
Yes, I did, ma'am. I understand them and I signed them electronically.
In cause number 2021 CR 3942, you're charged with the offense of retaliation. That's a third-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. In cause number 2021 CR 1793, you're charged with unauthorized use of a vehicle. That's a state jail felony. The range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
In each of the cause numbers, if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
In each of the cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent. Did you understand?
Yes, ma'am.
In each of the cause numbers, by entering these plea bargain agreements, you were giving up those rights. Did you understand?
Yes, ma'am.
And did you intend to give up those rights in each of the cause numbers?
Yes, ma'am.
Counsel. Sorry, just one moment. The screen did something very crazy on me, Brenna. It's trying to make it into a Monday, but I am not going to let it be a Monday. Oh yeah, there's all, just one second, everyone. There's a bunch of things that are happening. Wow. Something weird. Okay, we're just gonna go with what we have, everyone. Something weird has just happened to the screen.
Yeah.
There we are. Counsel, has your client been able to provide you with any defenses to any of these offenses?
Well, Your Honor, he's been able to assist me in his defense. And
Go ahead.
I was going to say, I believe he has a rational and factual understanding of the charges and the proceedings against him, and I believe he's competent to enter his plea.
And in each of these cause numbers, do you believe he was sane at the time of the offense?
As far as I know, he was, Judge.
Mr. Townsend, in any of these cause numbers, has anyone threatened you, coerced you, or forced you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I am, ma'am.
Are you a U.S. citizen?
I am, ma'am.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm going to show you what's entitled plea bargain page. Did you review that page with your attorney, and did you understand it?
I have, ma'am, and I did understand it.
In each of the cause numbers, according to the plea bargain agreement, punishment is to be assessed at 2 years in the prison. And of course, in the cause number 2021 CR 1793, that is 2 years in the state jail facility. Just give me one moment. And these cases are to run concurrently with each other. The state will take in consideration 2020 CR 3300. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor, with the stipulation that Mr. Nisbet and I have agreed that his credit will begin from December 16th of 2020.
All right, is that the entirety of the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver repeal in each of these cause numbers. Did you review that paragraph with your attorney? Did you understand it and did you electronically sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there hasn't, Judge.
Then, Mr. Townsend, in cause number 2021 CR 3942, how do you plead? Guilty, not guilty, or no contest?
No contest.
And in cause number 2021 CR 1793, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, do you have any evidence to support the defendant's plea?
Yes, the state offers states Exhibit 1 and its attachments for each case
Any-
separately.
Any objections?
No,
Mr. Townsend, in each of these cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them and did you electronically sign them in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Then in each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states Exhibits 1 and attachments in each cause numbers and review the same. All right, after reviewing states Exhibits 1 and attachments in each of the cause numbers, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty in each cause number. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor, other than obviously we'd ask you to follow the plea bargain. And again, Mr. Nisbet and I have agreed that his credit in both cases is to run from December 16th, 2020.
All right, the court will follow your plea bargain agreement in cause number 2021 CR 3942. The court will sentence you to 2 years in the prison, give you credit for the time that has been served since December 16, 2020. This is run concurrent with 2021 CR 1793. Take in consideration 2020 CR 3300. And in cause number 2021 CR 1793, the court will sentence you to 2 years in the state jail facility, give you credit for any time served. Credit will start from December 16th, 2020. Take in consideration 2020 CR 3300. This is run concurrent with 2021 CR 3942. Is there anything from either side with regards to sentencing in each of those cause numbers?
No, Your Honor.
No, Judge.
Mr. Townsend, in each of the cause numbers, I'm showing you what's entitled trial court certification of defendant's rights to appeal. Did you review those documents with your attorney? Did you understand them and did you electronically sign them?
Yes, ma'am.
All right, because this is a plea bargain agreement in each of these cause numbers, because I followed your plea bargain agreement in each cause, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
And in each of the cause numbers, because they are felony convictions, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
All right, we can go off the record. Mr. Townsend, you're gonna have to do better. Otherwise, you're gonna end up in and out of prison, okay?
Ma'am.
All right, good luck to you, Mr. Townsend. Have a great rest of your week.
You as well.
All right, thank you. Everyone, with that, we are done for today. We have another portrait unveiling ceremony for the former judges of the 187th District Court at 3 o'clock. I know I will see some of you there, but everyone have a good and safe fiesta. Bye, guys.